Heidi. Welcome to this e-module on comparative legal research, which is part of our series on legal research methodology. I am Perrine Simon, the liaison officer of the University of Luxembourg, based in Laos. During this presentation, we will talk about what is comparative legal research and how it can be useful for you. What is comparative legal research? Let's start with a definition. Comparative legal research is about comparing the rules of two or more legal systems. Most of the time, the comparison is done in space. This is to say between two states or more. For example, comparing state compensation law in Luxembourg and in Laos, and why not in Thailand as well. It can also be done in time, meaning in history, if a new legal system has been replacing another in the same space zone or same state. For example, comparative law in time could be comparing fundamental rights in France before and after the French Revolution, during the old regime and the new regime. Comparative legal research is about comparing. It is not simply about studying and describing in general the laws of two or more legal systems, but rather it is about finding and describing differences and similarities. Finding the differences and similarities and understanding them and explaining the results. For example, comparing two or three constitutional orders might lead us to question and re-examine core principles of our constitutional order, like freedom of speech or religion or equality. What do you compare in comparative legal research? Well, the law. The law is the object. As we have seen, the prerequisite of a legal research is to analyze legal sources, primary and secondary. You can watch the e-module on how to find reliable sources and also the one on how to design a good legal research topic if you want to know more about this. Depending on your topic, you will choose to look at a specific legal issues or a broader legal issues concerning, for example, the organization of a legal system. But anyway, you will necessarily look at primary and secondary sources. So what has to be compared will be either legislation, case law, socioeconomic or historical context of the law, or also what we call invisible powers or legal formats. I will explain. The last point, what we call the invisible powers, refers to the legal cultural component of the legal system. It's somewhat harder to grasp by reading the law. This refers to the cultural context, the way the law is understood and interpreted, which depends on the cultural context. So it might be important to pay attention to this for your research. For example, in a country, you may have an important informal way to settle disputes or customary rules that are not reflected in the legislation. So if you limit yourself to only read the law, you will miss this. So keep in mind, be careful, not all law is written. A deeper part of the law lies beneath the surface and is less visible. For example, in the United Kingdom, there is no written constitutions. The constitutional rules, they are a product of customary law. So you will not find a written document, a charter, with all constitutional rules. Law when you're doing comparative law, you need to understand that it sits within a culture and that it's influenced by the culture of the home country. This is why when doing comparative law research, it's important to understand the legal system of the other that you are studying. It's not because you copy-paste a legislation from France or Thailand or Luxembourg that the introduction of this legislation in Laos will lead to the same results. The law sits in a specific context, and that's why it's important for you to understand the characteristics of the legal system you compare. And for this, you need to know the main legal system families in the world. On this slide, you have a map of the legal systems in the world. In blue, you have the civil law countries, which can then be subdivided, where the main characteristic is that the law is written, codified, and the judge does not have the power to create the law, but only the power to interpret the law. In red, pink, you have the common law countries where the law was traditionally not written and where the judge is actually creating the law on the particular case that is submitted to him according to the set of precedents. Roughly, common law countries, they have derived their legal system from England, and civil law countries have derived from Roman law in continental Europe. So this is really important when you are doing comparative law to know to which system the country you're comparing belongs to. If it's a common law country, the role of the judge is more important, is creating the law. You may find less laws that are written, so you already know this when you're selecting your sample. Now, why doing comparative law? What are the aims of comparative law? Often, comparative law can be used to outline similarities despite apparent differences, and that can be used to harmonize legal systems. It will help you to know the system of neighboring countries if you have to cooperate with them, and if you're trying to pass a treaty to have laws that are more similar. But comparative law can also be used to put the emphasis on the differences and to better understand our own legal system. Comparing criminal law on a specific crime in Laos, Thailand, and France may show that there are big differences and help you to improve your legislation and change it. So remember that it can be used to reform, improve legislation of one's own country, but also to harmonize legal systems. Now, if you want to do comparative law, how do you choose the different countries that you will compare? First, because they are relevant for your research. For this, you need to do a preliminary research to spot the differences and similarities worth comparing. There must be a prime reason for engaging in the proposed comparison. So you may choose 2 or more countries that have a new legislation on a legal issue, or choose countries that have very different solutions on a specific legal issue. Remember that no systems are purely identical, but sometimes they are too close to find significant results. So take a moment to think. Can you find any examples that would be good? Well, you have been to a conference where judges were discussing how evidence can be gathered in criminal proceedings in Laos. Your hypothesis, your prediction is that the law is deficient because it's not specific enough about the procedure. You may consider to compare it with Thailand and France, which are both civil law countries, to see how you can improve evidence gathering and admissibility in Lao law. But can you do this if you don't read or speak Thai, nor read or speak French? No, because you should know the language of the countries you are comparing. You need to be able to read and understand. You need to be able to read and understand the original legal source. There can be, of course, some problem of legal translations, and you should be able to read the original document, not a commentary or not a translation. You should also be careful with false friends in legal translation, because the same technical term can have a different or slightly different meaning than in your own country. Because the same term has developed differently in both countries. It has been interpreted differently by the courts. One example, you know, the concept of rule of law is different than état de droit, which is often given at the translation in the French legal system. They more or less mean the same, so they're often given as equivalent, but they're not exactly the same. So studying the two concepts in a comparative legal research might be of interest. So except language skills, what are the important skills of the comparatists? It is important to avoid the native bias. You need to be a scientific and neutral observer. So don't think that the legislation is necessarily better in your own country, but on the contrary, don't think that it's necessarily better elsewhere and that we should adopt the same legislation as France or Thailand again. You should have critical reasoning skills. You should always assess the data that you collected within its cultural context, the socio-economical context, but also historical context. For this, start with the similarities, then the differences, and then step back from the legal order under review and distance yourself from it. Describe, then understand, then assess the results. You need to be able to identify the origins and major characteristics of a legal system. What are its main institutions, funding, legal principles, etc. So you need to be able to compare legal concepts and institutions across the two or more systems that you will have chosen. As we already mentioned, it's important to explain the cultural context and the cultural mentalities in your comparative legal research. Law cannot be understood without understanding the culture it sits in. For example, we cannot really understand the French Revolution today without an appreciation of the influence of 1789. So in this case, you will need to refer to the historical method, looking at history. Now, how to perform comparative legal research. You need to have a toolbox of questions that you can ask yourself. How are the systems similar or different? Are the similarities differences based on words in legislation or court's decision, on context or something else? What is the concrete meaning of the difference or of the similarity? What does the similarity difference reveal? Is there something in the other system that you're studying that can improve your own system? Is my own system effective? So keep in mind this toolbox if you're doing any comparative law research and apply it to your research. Now let's look at some examples of comparative research. Here we have an example of a comparison comparing the freedom of speech in the USA and in Europe. Let's imagine you do this. You will have to compare one common law country, the US, with Europe or one specific European country, which are, except of the UK, civil law countries. Where do you start if you have to do this? Well, you will have to look at the text, the provision of the laws, but also at the case law of constitutional courts, because they are the institutions that are deciding on fundamental rights. So always keep in mind that the text is not enough, but you need to look at the way the text is interpreted by the courts. And comparing the USA and Europe could be interesting because in the USA, free speech is textually in the Constitution protected without limitation, but the US Supreme Court, when it interprets this constitutional right, limits free speech if a clear and present danger is present. In most European countries, freedom of speech is protected, but we have limitations in the text. And these limitations, of course, then they are interpreted by the courts as well when there's a case raising a question of freedom of speech. If you are interested in constitutional law, you could do a comparative legal research on a topic, choosing a right that is in the Lao Constitution, the right to education, movement, religion. You can take the Lao Constitution and looking at the rights that are enshrined there. If you were asked to compare anti-trafficking laws in Laos, Thailand, and Malaysia, what would you do? As we said, you would need to speak the language, and you may want to look at their legislation. Is there a recent legislation on the topic of anti-trafficking? Has there been any court decision on this legislation? So here you would not necessarily have to do interviews of people at the ministry, but you would need to be able to access the legislation and court decision. And usually, I guess for Thailand and Malaysia, you could find them online, and you could even do this research from here if you speak the language. You could decide to compare criminal procedures in the ASEAN to facilitate mutual legal assistance. This would be a big research because there are many states, so you might need to be a team of experts from different countries to do such a research. The picture I've put here is a research that I participated in, where we did exactly this, looking at criminal procedures across 5 countries of the EU with 5 national experts, each writing a report on their own country. So this research was actually commissioned by the European Parliament. They funded the research because they wanted to see if it was necessary to harmonize more the law on criminal procedures of member states to facilitate mutual legal assistance. So this is one example where you see that comparative law can be used to facilitate cooperation. This could be done in commercial matters, but also criminal matters, to harmonize legislation. Now we have included in this presentation a few examples of already existing comparative research that has been published in Asia. Here we have a paper co-authored by Mr. Li and Wu about the assessment of the jury system in Asia, a comparison between Korea and Japan who was published at the Asian Journal of Comparative Law in 2019. And in this article, the authors, they show how Korea has experimented with both the German and US models of jury trials, whereas Japan based its jury system mainly on the US system. So it's an interesting comparison showing how two Asian jurisdictions have adopted two different Western models. Here we have another recent reference, a paper co-authored by Margie D. Weiser and Nok Son Bui about contemporary constitution making in Asia Pacific, published in the Chinese Journal of Comparative Law. So you have here a comparative research looking at constitution making since the late 19th century, looking at East Timor, Thailand, and Nepal, as well as Myanmar and Sri Lanka. It might give you an idea to write a paper on constitutional making in Laos. The constitution was revised in 2015. You could compare it with Thailand and another country which have also revised their constitution recently. And I just want to mention that Nok Son Bui is a Vietnamese professor who has also been writing about Laos and the Lao constitution in English. I think he's a professor in Hong Kong. And here we have now a reference of a book on examining practice, interrogating theory, comparative legal studies in Asia, looking at how legal transplantation and reform in the name of globalization is central to the transformation of Asian legal systems. So you see that there are a lot of academics in Asia that are writing about comparative law, looking at how, you know, one country is borrowing from the legal tradition of another one and transplanting a new concept or new rights in the constitution in Asia. So I hope this can be inspiring for you. And before finishing this presentation, a few practical advice on writing a comparative law research paper. Make sure that the topic is researchable, that you can find and read the data you will find. Don't avoid a topic simply because you know nothing about it. You can search in the library, online library, or on internet as well. After choosing a certain topic, focus on one or two questions that you would like to answer. Focus on one legal aspect in a given area and compare this aspect within two or more legal systems. And focus on legal issue. Remember that you're not writing a political science or history paper. Find comparative law journals to read them, but also maybe to submit your article. The Asian Journal of Comparative Law, the Korean Journal of International and Comparative Law, the Asia Pacific Law Review, the Indonesian Journal of International and Comparative Law. And maybe if you want to be able to write in Lao, you can think of a Lao Journal of Comparative Law for the future. This was the last slide. Thank you very much for your attention and for joining us. If you have any question, you can contact me by email, or for questions about legal research generally, you can look at our new website to see our activities, and I hope to see you soon. Bye-bye.